let's get into the details of this a little bit real quick. Rahimi himself has been found to be dangerous, right? There was a finding of dangerousness as you talked about at the beginning of this. How does that play into your arguments? Like, does it, if he's been found to be dangerous and he's the one challenging this law, does that matter? Given that you're saying the second part of the statute is what's really constitutionally problematic, does it matter that he meets the first one too? How does that play out in court?
That will be an interesting thing to see, and it's not my problem. The Supreme Court will figure out what to do with that. And as our brief says, this connection between C1, credible threat, finding of a credible threat, and C2 is, or C2, just to leave each other alone, order not based on any findings at all. The court maybe could say, well, C2, the thing that is an infringement, can be severed from the rest of the statute. And since Rahimi clearly falls under C1, it's okay to go ahead and prosecute him. That's a possible result in the case.
Okay, so the court, that was going to be my next question. The court could choose to say just this part that doesn't have a finding of dangerousness involved is unconstitutional, and the first part is not. We're just striking down this one part, but that would be an interesting outcome, right? They uphold Rahimi's conviction, but say part of this law is unconstitutional. I guess that's why they write in those severability clauses in a lot of these federal laws, right?
Right. When the gun severability is generally presumed by courts, but some legislatures, with the proper way of belt and suspenders, which is the best way to do something, to be sure to get what you want legally. The Gun Control Act of 1968 actually has a section in it that says everything is severable. So if you find something wrong with some part of it, we, Congress, still would have enacted the rest, even if that part we couldn't. It turns out we can't legally enact.
Okay. So, I guess ideal outcome in your mind would be, at the very least, to strike down that C2 portion.
Precisely. Yes.
Yeah. And you're not as concerned about whether or not Rahimi's conviction is upheld. It's more about this law itself.
That's exactly right. And our brief is only about the who of who can have their Second Amendment rights limited. We don't get into some topics that are covered in other briefs, including the one by Rahimi's, the very well-written, excellent brief by his federal public defender, which is that there's not enough due process in how this goes on, or that even the things that I talked about, like punishing somebody who has been causing terror to the public in a public place, they would say, well, that's true, but you didn't just take away Rahimi's right to carry a gun. You made it illegal for him to even possess a gun in his home. And that our brief doesn't get into that on one side or the other.